Deeds are the primary legal instruments used to transfer ownership or interests in real property in Arizona. Each deed type serves a distinct purpose depending on the transaction, ownership status, or desired level of protection for the buyer and seller. Understanding their legal definitions under Arizona law ensures proper use and recording of property conveyances. Deed of Trust, ARS. Paragraph 33802. A deed of trust established under ARS, paragraph 33802, is a security instrument used in Arizona in place of a traditional mortgage. It involves three parties: the truster, borrower, the trustee, neutral third party, and the beneficiary, lender. The truster conveys legal title to the trustee as security for repayment of a debt to the beneficiary. Once the loan is fully repaid, the trustee reconveys title back to the truster. If the borrower defaults, the trustee has the power to sell the property through a non-judicial foreclosure process, making this an efficient and commonly used financing instrument in Arizona. Trustee, ARS, paragraph 33-801-10. The trustee, defined under ARS, paragraph 33-801-10, is a neutral third party, often a title company, attorney, or financial institution, appointed to hold title to the property in trust for the lender. The trustee's role includes reconveying the deed when the loan is paid in full and conducting the trustee's sale if the borrower defaults. The trustee must act impartially, ensuring that the process follows all statutory notice and timing requirements. Truster, ARS, paragraph 33-801-11. The truster, defined in ARS, paragraph 33-801-11, is the borrower or property owner who conveys title to the trustee to secure a debt. The truster retains equitable title, meaning they have the right to use and occupy the property while repaying the loan. Once the obligation is satisfied, the truster receives legal title through a deed of reconveyance. Beneficiary, ARS, paragraph 33-801-1. The beneficiary, as defined under ARS, paragraph 33-801-1, is the lender or creditor who benefits from the security interest created by the deed of trust. The beneficiary has the legal right to enforce repayment and to initiate foreclosure proceedings if the borrower defaults. Upon full satisfaction of the loan, the beneficiary instructs the trustee to release the lien. Paid in full, ARS, paragraph 33-714. Under ARS, paragraph 33-714. Once a deed of trust or mortgage has been fully satisfied, the beneficiary or lender must cause a release and reconveyance to be recorded within 30 days. This ensures that the property title is cleared of any lien and confirms full repayment. Failure to release a lien promptly can expose the lender to penalties and damages. Requirements of deeds. ARS, paragraph 33-401. ARS, paragraph 33-401, sets the statutory requirements for a valid deed in Arizona. A deed must be in writing, include the names of the grantor, seller, and grantee, buyer, be signed by the grantor, include a legal description of the property, be acknowledged before a notary public, be delivered and accepted by the grantee to be effective. Without delivery and acceptance, the transfer is not legally binding. Recording the deed provides public notice and protects against future claims or disputes. General Warranty Deed, Grantor and Grantee Definitions. ARS, paragraph 1-215-13 and 1-215-12. A general warranty deed provides the highest level of protection to the grantee, buyer. The grantor, defined under ARS, paragraph 1-215-13, is the person conveying the property, while the grantee, under ARS, paragraph 1-215-12, is the recipient. The grantor guarantees that the property title is free from all defects, both known and unknown, and agrees to defend the grantee against any future claims. This deed type is commonly used in residential resale transactions to ensure the buyer receives a clear and marketable title. Quitclaim Deed, ARS, paragraph 32-402. A quitclaim deed, as established in ARS, paragraph 33, 402, transfers whatever ownership interest the grantor currently has in the property without any warranties or guarantees. This deed is often used between family members to clear title defects or to remove or add a spouse's name to the title. Because it offers no assurances of ownership or liens, it provides the least protection to the grantee. Beneficiary deed. ARS, paragraph 33, 405. A beneficiary deed under ARS, paragraph 33, 405 allows an owner to designate a beneficiary who will automatically inherit the property upon the owner's death, bypassing probate. The deed must be recorded before the owner's death to be valid, and the owner can revoke it at any time. The beneficiary has no ownership rights during the owner's lifetime, ensuring full control remains with the grantor until death. This type of deed is often used as a non-probate estate planning tool. Beneficiary. ARS, paragraph R33801. The beneficiary referenced here is consistent with ARS for 338011, meaning the person or entity named to receive benefits under the deed, whether as a lender in a deed of trust or as a named inheritor under a beneficiary deed. Disclaimer deed. ARS paragraph 14, 1006. A disclaimer deed under ARS paragraph 14 to 1006 is used between married couples to declare that one spouse has no legal interest in a property being acquired as the other spouse's sole and separate property. This is typically used when one spouse purchases property individually, and the other must formally disclaim any community property interest to prevent future ownership disputes. The disclaimer deed must be executed, notarized, and recorded for the disclaimer to be valid. Together, these deed laws establish how ownership rights are conveyed, secured, or relinquished in Arizona. Understanding the legal distinctions among them allows real estate professionals to ensure proper documentation, minimize liability, and protect their clients during property transfers.